Magandang hapon po, Luzon, Visayas at Mindanao. Ito po ang Paglilitis, Katarungan para sa Bayan. Ako po si Mark Castrod.
Ako naman si Veronica Jimenez. Samahan niyo kami sa paghatid ng live coverage sa pinagsamang lakas po ng PTV, IBC 13, Radyo ng Bayan, 15 community channels, pati na sa www.angpaglilitis.ph. At pwede kayong makilahok dito sa pag-uusap sa pamamagitan ng Facebook at Twitter. Pero ngayon po, puntahan muna natin ang ating kasamang si Von Aquino na nandyan sa labas ng Senado. Von?
Yes, Nika. Ngayon nga ay na pinapalayo ng mga pulis ang mga tapat ng Senado dahil may kitang isang kahina-hinalang itim na bag na mayroong tripod na iniwan sa tapat ng Senado. Ganap na alas 7 umano ng umaga at sa ngayon ay dumating na ang mga SWAT team ng Pasay City upang kilatisin nga itong bag. Pero sa ngayon ay pinapalayo muna ang mga miyembro ng media pati yung mga tao nandito sa ng Senado dahil peligroso nga kung sakaling mayroon daw laman na pampasabog itong itim na bag. At sa ngayon ay medyo nagkakagulo pa. Wala na nga pinadadaan na mga sasakyan dito sa tapat ng gusali ng Senado. Dahil balak nga ng SWAT team na inspeksyonin na itong bag anumang oras ngayong araw. At kinordon na nga itong bahagi ng tapat ng Senado at pinalayo na lahat ng tao dahil sisimulan na umano ang pag-inspeksyon dito sa kaduda-dudang bag na iniwan sa tapat ng Senado. At hinihintay na lang natin any moment dahil meron na rin kaming nakitang mga K9 units dito na talagang naka-assign dito sa Senado para sa seguridad ng impeachment trial, no? Pero sa ngayon ay pinapalayo pa rin ang mga tao at wala pa kami nakikitang lumalapit na SWAT doon sa mismong bag. Nika?
Yes, Von. Ito ba, mukha kasing suitcase ng equipment ng mga TV crew, ano? Anong sinasabi ng mga otoridad dyan? Hanggang ngayon ba wala pang lead kung ano yan?
Alam mo kasi wala daw nag-claim itong bag simula alas 7 ng umaga, 6 na oras na nga nakakaraan, no? Kaya naman nagduda na yung mga kapulisan at pinalayo na yung mga tao dito sa bag na ito. Wala nga makapagsabi kung ano nga ang laman nito dahil natatakot din ang mga pulis. Ayaw nila itong ipagalaw dahil sakali nga na may pampasabog ito, talagang delikado at ayaw din palapitin yung mga camera dahil sa oras daw na may pampasabog ito, baka maging detonator pa yung radiation na nagagaling sa mga camera ng mga TV crews na pumapalibot dito sa tapat ng Senado, doon nga sa may suspicious bag na iniwan.
Pero sa pangyayaring to, tuloy pa rin ba itong paglilitis ngayong hapon o kinansela na? What is happening?
Wala pa namang cancellation tayong advice na natatanggap, Nika. No, sa ngayon kasi ay siguro inspeksyonin muna ng mga pulis itong iniwan na baggage bago pa man siguro sabihin kung peligroso o hindi itong bag na ito dahil lahat kami dito ay nagtatanong pa rin kung nagtataka kung ano nga ba ang laman nitong bag at yung mga pulis din wala silang ideya kung ano nga ang laman nito kaya para makasiguro yung mga SWAT ang siyang mag-iinspeksyon sa bag na ito.
Von, ang nakikita natin sa screen ay mga pulis at SWAT. Ang katanungan ko, nandiyan na ba yung bomb disposal squad, yung talagang spesyalista sa pagtugon sa mga problemang ganito?
Sa ngayon kasi yung SWAT lang tsaka yung mga PNP personnel ang nandito. Pero meron na rin tayong nakitang K9 dito malapit sa kinordon na bahagi ng Senado. At wala pa nga lumalapit na bomb disposal team dito sa ngayon. Mark?
Okay, sana Nikki, matuloy pa rin itong there's a breaking incident just before the fourth day begins.
Merong mga meron dalawang miyembro ng SWAT dito sa may tapat ng malapit doon sa bag na naglalakad-lakad sa loob ng kinordon na lugar dito sa tapat ng Senado. Ngunit hindi pa nga nila hanggang sa ngayon nilalapitan yung bag at hinihintay pa natin. Ito na pinapalapit na yung lalapit na siguro itong K9 unit na para inspeksyonin na. Simulan na ang inspeksyon doon sa bag at hintayin natin.
Ito bomb sniffing dog. Masasabi nitong asong to parang meron siya signal na uupo pag umupo, hindi ba parang ibig sabihin nun bomb yun, ano?
Papalapit na ang member ng SWAT kasama itong bomb sniffing dog. trained itong asong ito para i-detect kung merong ang bomba sa isang gamit.
Ayan na.
Titingnan
Pero
natin.
hindi pwedeng galawin yan, ano? Because baka kung matouch yan, maaaring sumabog. He's just going to sniff it. Mukhang hindi. Mukhang hindi. Kasi hindi siya, hindi siya umupo eh, no? Natatakot yung aso.
Normally umuupo ang aso.
Oo. Oo.
Normally umuupo ang aso
Ayaw eh.
kung merong na-detect. Pero ito lumalayo ang aso.
Parang wala, hindi siguro, no?
Hindi natin
Wala eh.
Sa ngayon, Nika, Mark, patuloy pa rin yung pagpasok ng mga sasakyan dito sa may parking lot.
Well, in the meantime, habang chine-check ito, no, yung mga tao abala din dito sa loob ng Senado at naghahanda na nga sa pagsisimula ng paglilitis ngayong 2:00 ng hapon. So there is no notice of any cancellation whatsoever because of the incident outside the Senate. No?
That's right. And Nikki, sa ating balita, the order of the Senate yesterday for pre-marking was conducted earlier. Natuloy yung pagmarka nitong mga dokumentong mahalagang ipepresenta sa araw na ito para po maiwasan yung nangyari kahapon na delay dahil lang sa pagmamarka nitong mga dokumentong ito. Kaya makakaasa siguro tayo ng mas mabilis na proceeding sa hapong ito. We're just hoping that this situation is resolved soon.
Sana hindi naman bomba. Mukhang hindi naman kasi hindi nga umupo yung aso. But we're waiting for the actual bomb squad to come and buksan itong maletang. Yung maleta kasi kailangan buksan eh para malaman kung talagang may bomba dyan o wala. But initially parang hindi. However, they're still cordoning off the area. Hindi nagpapalapit ng mga tao para lang sigurado kung sakali nga namang may sumabog, baka may masaktan. So,
itong mga parang naghahalo yung kaba ng ating mga kababayan dito sa scene na ito dahil nga mahalaga para sa ating bansa ang nagaganap sa Senado at lahat tayong interest natin ay makamit ng hustisya. I'm sure both on the side of the Chief Justice of the Supreme Court pati na rin yung prosecution, nais nating makita kung ano talaga ang resulta nitong buong prosesong ito. And incidents like this can only cause greater anxiety sa ating lahat.
Yes, and I hope this will not delay the opening of the hearing later on at 2 o'clock. Because this morning, nag-marking na sila nito mga ebidensyang ipinipresenta ng prosecution panel, no? So, inumpisahan niyan kaninang 10:00 ng umaga.
That's right. So, we will give you a report on the progress dito sa nagaganap na pag-inspect dyan sa naiwan ngang maleta sa harap ng Senado. But in the meantime, let's introduce yung ating mga kasama sa studyong sa umagang ito para bigyan tayo ng kwento kung ano nga ang kanilang impresyon sa nangyari kahapon at sa mga inaasahan nilang magaganap sa araw na ito.
Okay, we have for the defense panel the spokesperson Karen Jimeno, and we also have Attorney Erin Tanyada, Deputy Speaker of the House and also spokesperson for the prosecution panel. Magandang hapon po sa inyo.
Magandang hapon. Nikki at
Okay, yung mangyayari ngayon, alam natin that they have started marking yung evidence na ipipresenta nitong prosecution panel. Ilang ebidensya ba ito at ilan ang inaasahan ng mga testigo ngayong araw na to?
Well, hindi ko po alam kung ilan talaga ang pinamark, no? But kung pagbabasehan po yung number of witnesses, so practically the titles of the documents that we're going to be presenting this afternoon. So if there are four register of deeds, so the different titles with regard to those specific cities.
So itong nakita nating delay kahapon, Congressman, maiiwasan na yon completely today?
Sa tingin ko may iwasan naman today yung delay sa marking. Ang hindi ko masasagot kung marami pong objections ang ating kaibigan na si Justice Cuevas.
Bigyan lang natin ng konting update, Congressman, no? Nikki, na yung tinalian, yung maleta, at hinila sa isang corner ng
Papasok
building.
sa gate, no? This is the gate, yung kabilang parking area. Yung merong mas konting tao, but that's where our yung ating yung PTV na yung naka-istasyon, yung tents namin but okay, they pulled it over there because mas konti yung tao dyan, and then they're trying to get it para ma-secure, at kung may bomba man ito, at least mailabas na, no? At doon na sa labas
Ngayon,
bubuksan.
in fact, kinarga nila sa isang sasakyan ng SWAT at they're motoring it out of the premises of the GSIS of the Senate. So, wala na po yung programa. Yung problema po pala. Tuloy yung programa. Okay.
Alright.
Alright.
Yes, recap lang muna tayo mga highlights yesterday, no? What happened? Nagpresenta ng witness si Attorney Enriqueta Vidal, the clerk of the Supreme Court, and we will see also ano pang nangyari. Meron
We have
tayong
prepared a video to give us a complete view of the event yesterday. Yan po ang kaganapan kahapon, day 3. Napapasok po tayo sa day 4, alas 2 ng hapon po ang takdang simula ng paglilitis ngayong araw na ito. At mapalad po tayong kasama natin, spokespersons ng bawat panig, Congressman Aaron Tanyada and Attorney Jimeno. Nabanggit na ni Congressman Tanyada na may iwasan yung delays because of the marking. Yung mga procedure naman yon. On technicality naman, Attorney Jimeno, pakipaliwanag sa ating mga kababayan kung bakit parang tilang object si Associate Justice Cuevas.
Si Justice Cuevas kasi isang seasoned litigator. So, bilang abogado, alam na alam niya yung rules of evidence, rules of court. So, natural lang sa kanya na pagka mali yung pagkabigay ng question ng prosecutor ng kanilang abogado, nag-o-object siya. So, dahil nga strict ang kanyang application ng rules at sinusunod niya ito ng mabuti.
Ito namang prosecution, masaya daw kayo dahil ultimately nakuha niyo yung gusto niyo, itong SALN.
Well, ito yung unang hakbang, no? Hindi namin pwede naman sabihin na galak-galak at jumping for joy, no? Pero ang pagtingin po namin dito sa pag-disclose, no, paglabas ng SALN at pagbigay sa Senado, ito yung unang hakbang para makita po natin kung ano ba talaga ang totoo, no? At dito natin malalaman sa mga susunod na araw kung itong SALN ba dito ay talagang reflective ba sa sinasabi po ng ating punong maestrado or baka mamaya hindi pa natin alam, no? So tingnan natin.
Pero looking at it initially, nakikita natin yung figures, no, from 2002 hanggang 2010. We started with 14.96 million, and then in 2010 it was 22.938 million. Just looking at this, ano yun, pwede na bang, ano yung impact nun? Pwede na bang kayong magsabi na merong tagong yaman dito? O
well,
merong...
Kung titingnan as is just like that, no? Ang dapat makita natin, sa 10 taon na siya po ay wala sa hudikatura, no, constant po yung kayamanan po ng net worth ni punong maestrado. At yan po ay naglalaro between 13 and 14 million sa 10 taon. Pag titignan po natin yung figura na nandyan, in 2003, mga 7.3 million. After 8 years, naging 22.9 million, almost 23. So, in a span of 8 years, nagkaroon ng pagtaas.
Okay.
No?
So, pero yung interpretasyon niya na Congressman, mukhang doon magaganap sa trial mismo.
Doon nga. Kaya nga, sabi nga namin, ang SALN ay unang hakbang lamang tungo sa katotohanan.
Kay Attorney Jimeno, ang sinasabi ni Chief Justice ay wala siyang tinatago. At sabi niya, nais niyang lumabas ang katotohanan. Pero nakita nga ng ating mga kababayan na inoobjekan na ni Associate Justice Cuevas yung pagpapalabas nitong SALN. Ngayon, na lumabas na talaga itong SALN, ano ang tingin ng depensa?
Mark, ikaklaro ko lang yung pag-object ni Justice Cuevas, hindi dun sa dahil ayaw niya lumabas yung SALN. Pag pinakinggan nyo, siguro mahirap intindihin to ng pag hindi ka abogado na bakit nga ba siya nag-o-object. Yung mga in-objectan niya kahapon, yung mga kung paano i-phrase yung questions. Kasi nga naman, witness yan ng prosecution, pero yung paglabas nila ng question para bang sinisira nila yung kredibilidad ng sarili na lang witness. At ito rin naman yung sinabi ni Senate President. Iklaro nyo kung kaninong witness ba to. Kasi nga, meron tayong mga rules sa court at sa ebidensya na kailangan nyo sundin.
Gusto ko tanong kay Congressman Tanyada, dahil kahapon nga nakuha natin, parang all's well that ends well, kumbaga, sana. Pero meron nga tayong technical hurdles kahapon at nangyari nga, merong konting technical difficulty yung ating prosecuting panel. Anong gagawin nating remedyo or improvement on that aspect?
Sa tingin ko, hindi naman masyadong technical, no? Meron nga binabanggit, ang nagpalabas ng SALN ay yung senator jurors. Kung talagang naging tapat rin sa sagot ang ating testigo, no? Dahil tinanong naman siya ni Attorney Bautista kung dala mo ba yung SALN. And sa transcripts, ang sagot, I am restricted because it says here in one of the guidelines. So, if you look at it, no, and you listen to what she said, parang hindi niya dinala. No? So, hindi niya, in-evade niya yung tanong, pumunta po siya sa guidelines, kaya ang pagkakilala ng lahat, and I think, even Senator Drilon, so, na baka walang dala. Kaya there was even the talk na baka mag-issue ng panibagong subpoena, no? Maybe in the demeanor, kaya nga, ang tanong, bakit yung mga senator judges ay nakaharap sa testigo at hindi kay Senate President Enrile, para sila rin mismo ay nanunood sa demeanor ng isang testigo kung makita nila kung paano siya gumalaw, paano siya sumagot, no, anong facial expressions niya, doon makikita kung merong tinatago yung isang testigo, hindi.
So ngayon, ilalabas nyo yung mga ibang ebidensya na magpapatunay na, kasi parang ang gusto nyong i-prove dito, marami siyang tagong yaman na hindi niya idineklara sa kanyang SALN, di ba?
Well, tama po yun, no?
So, ang mga lalabas ngayon ay yung mga city assessors, yung mga registers
Register of deeds, yes,
yung lahat
to
ng yun.
authenticate yung mga iba't ibang.
Oo, pero how will the prosecution connect itong sa kanya nga, kung yung mga sinasabi niya, hindi naman nakapangalan sa akin. 5 lang dyan yung nakapangalan sa akin.
Well, nasa strategy na po yan. No? At we will leave it to our prosecuting team sa floor kung paano nila may lalabas.
At yung defense team naman, yung itanungin ko lang yung strategy nila, no? Because already, lumabas na yung SALN at nakita nga sa SALN, sandali, yung bang 5, kung tusumahin mo, na inaamin niyang kanya, 22 million ba lahat lang yun, yung total nun?
Mahirap kasi, una-una hindi namin pwedeng sabihin yung strategy din namin, at lalo na't ongoing yung court proceedings, di ba? Pero mahirap gawing basihan yung totals na linalabas niya sa SALN kasi hindi mo makikita kung ano ba talaga yung linalaman yan dahil nga andyan yung liabilities. Hindi natin alam kung may mga nabayaran siyang utang kaya biglang hindi mo ka nagmaminus ng liabilities bigla or baka naman nakapagbenta siya ng mga dating properties na tumaas yung value nung time na binenta niya, kaya biglang lumaki. And sinasabi ko, hindi natin alam. So, kaya nga kailangan natin antayin yung proceedings, yung paglilitis ng yung SALN.
Nakikita natin, Attorney Jimeno, o nakita ng ating kababayan at Associate Justice Cuevas, parang mention na they're objecting. Meron silang objection dun sa buong linya ng pagtatanong na yon. There's a continuing objection dun sa proof na iprueba yung ill-gotten wealth. Kaya, ano ba, magtutuloy ba yon na yun ang magiging major clash point? Whether prosecution can prove ill-gotten wealth at ang sinasabi ninyo, hindi nila pwedeng i-prove niya because hindi proper yung pagka-allege sa articles. Yun pa rin po.
Maski hindi sabihin ni Karen yan sasabihin ko mag-object at mag-object. Makinig sa akin. Alam ko mag-object. Ano ba?
Bilang abogado, obligasyon niya yun. Kasi unang-una, ang basihan niyan, yung due process rights, yung karapatan ni Chief Justice Corona sa due process. Kasi kung yan ba yung inilalaban nilang aligasyon noong umpisa pa lang, bakit hindi nila ginawa ng sariling article yan? I'm sure kung malaking ebidensya nila dyan, isang buong article yan, na article of impeachment. Ngayon, ang nakalagay dun sa article 2 na malinaw-malinaw ay ang failure to publicly disclose si SALN. So, sinasabi nila ngayon, hindi, meron naman dyang mention na kasama yung ill-gotten wealth. Pero pag kinignan mo yung paano nila sinabi, nakalagay suspects, ang requirement sa atin, personal knowledge. So, mahirap kasi yung...
Attorney, gustong-gusto na Nikki sumagot ni Congressman Tanyada.
pero bago kayo
Ipilin muna natin ang konti.
yung mga nangyari...
Tinitignan ko lang.
yung mga nangyari kahapon, tingnan muna natin ulit para yung ating mga viewers talagang mas maintindihan
Mas
itong
visual.
diskusyon natin.
Ang SALN ni Chief Justice Renato Corona na dinala ng Supreme Court Clerk of Court ang naging sentro ng ikatlong araw ng impeachment trial. Sa presentasyon ng prosekusyon ng ebidensya kaugnay sa umano'y non-disclosure ni Corona ng kanyang SALN, unang sumalang sa witness stand si Supreme Court Clerk of Court Enriqueta Vidal. Sa kalagitnaan ng pagtatanong ng private prosecutor, biglang kinumpirma ni Vidal na dala niya ang SALN ni Corona. Yun nga lang, nagdalawang isip si Vidal na isurrender sa impeachment court ang naturang SALN dahil na rin sa umiiral na en banc resolution ng Korte Suprema kaugnay sa paglalabas ng SALN ng mga mahistrado.
At this point, you have not brought the statement of assets, liabilities, and net worth asked for in the subpoena.
I have brought them with me. I am really in a quandary. I'm in dilemma because we are covered by the rules of the Supreme Court.
Base kasi sa Supreme Court en banc resolution noong May 2, 1989, kinakailangan munang aprubahan ng Korte Suprema ang paglalabas ng SALN ng mga maestrado. Kaya naman sinabi ni Vidal na wala sa kanyang kapangyarihan na magdesisyong isurrender sa impeachment court ang SALN ni Corona. Kinontra naman ng ilang senator judges ang pag-atras ni Vidal na isumite ang SALN ni Corona sa impeachment court, pwera lamang kay Senador Joker Arroyo.
Kung ang sinasabi po ng inyong punong maestrado na wala po siyang tinatago, regular po siya nagsasubmit ng SALN, bakit hindi niyo po maibigay ang SALN sa amin para makita namin, para malaman ng buong katotohanan kung talagang nagsusumite siya ng regular sa inyo, at para na rin malaman ng taong bayan ang buong katotohanan. Huwag na ho kayo magpatumpik-tumpik pa, huwag na kayo humingi ng permiso sa Korte Suprema. Ang sundin ninyo ay ang subpoena na in-issue sa inyo.
But we cannot have another problem of a clash between the Supreme Court and Congress in our desire to have a fair trial. Let us not, I hope the two parties will agree, both the prosecution and the defense, give her a day to ask the Supreme Court whether it's all right for her, rather than using the strong arm.
Sa huli, ipinag-utos ni Senate President Juan Ponce Enrile na i-turn over ang SALN ni Corona sa impeachment court. Pinayagan din ng impeachment court ang prosekusyon na markahan ang mga dokumento.
The chairs has ruled that we now require and order the witness to surrender to us the SAL the pertinent SALN that she brought to this court. So ordered.
Sa pagtatanong naman ni Senator Francis Escudero, sinabi ni Vidal na mula pa noong 1989 nang ipalabas ang en-bank resolution, hindi pa ni minsan nagpahintulot ang Korte Suprema ng paglalabas ng SALN ng mga justices. Plano naman ng prosekusyon na pabaliking muli si Vidal upang tumestigong muli sa impeachment court sa mga susunod na araw. Para sa People's Television, Von Aquino.
Yan po ang pag-wrap up ni Von, no? Pero mukhang non-issue na nga, Nikki.
Yes,
Oo,
oo.
pero itong lahat ng ito, importante pa rin dun sa diskusyon. Pwede bang i-prove yung ill-gotten wealth? At mukhang sinasabi, there was failure to comply with the rules of pleadings kung paano sabihin. Pero on the other hand, sasabihin semantics lang. Congressman, pakisagot.
Para sa akin, at the end of the day, ang magpapasya niyan talaga yung Senate Tribunal. No? There will be oral arguments on both sides. Sasabihin, hindi kasama sa title, kasama naman sa body. No? Alam naman natin yung mga abogado yan. And we will have to leave it to the wisdom of the Senate Tribunal kung ano yung magiging decision po nila. No? But again, not necessarily being if they vote against that, it does not necessarily mean that we can not prove certain other things about that salary.
Using other evidence, no? Pero kahapon lumabas yung balita na maaari niyong tawagin si Chief Justice Corona para tumestigo. Or how,
For the defense?
What factors are going to push you para tawagin si Corona na mag-testify?
It's hard to say what factors because we're still at the beginning of the trial. And so far, it seems that it's unnecessary for him to testify. And of course, this is part of the strategy of the defense, tsaka kung ano rin yung mangyayari during the course of the trial, kung kakailanganin ba siya tumistigo.
Gusto ko itanong kay Karen, Attorney Jimeno, no? Yung SALN kasi, yung pagkakaintindi ng taong bayan, Attorney, is really for the purpose of revealing kung ano yung ari-arian na para masiguro na walang yung hidden wealth. That's precisely the reason why they have a SALN. Hindi ba yun yung mismong tinutumbok na kaya nga pinapaproduce yung SALN para makita kung merong ill-gotten wealth?
Well, wala kaming problema doon. Kung from the start, ang allegation nga, meron siyang ill-gotten wealth. Ang nakalagay kasi sa allegation doon, failure to publicly disclose. So yung pinapangamba namin na from the start pa lang ay wala sila talagang ebidensya na may pagsasala si Chief Justice Corona. Kaya ang gusto nilang clear allegation ay yung may personal knowledge nilang hindi niya nagawa, which is public disclosure of his SALN. Pero alam din naman natin hindi niya nga pwedeng gawin yon kasi en-bank resolution nga pinagbabawal yon. So, parang siningit nila yun doon para just in case makuha nila to, maghahanap kami ng ebidensya na may ill-gotten wealth siya. Pero hindi nga natin pwedeng gawin yan kasi may due process rights yung tao. And kung gagawin natin to sa lahat ng mamamayan na mag-file ka lang na mag-file basta may nagsususpetsa ka, paano na lang ang Pilipinas at ang demokrasya?
Oo, yung balanse no, Nikki.
Yes, paano yun? Pero nakita natin, no, parang hindi masyado sa technicality. Kasi this is different yung rules of procedure dito, no? So, and we also saw the judges parang asking their own questions na parang minsan nakakatulong sa prosecution din. Yung iba naman, of course, they were talagang very strict sa ito yung nangyari.
Yung pagtatanong, okay lang ba sa depensa yon so far?
Mahirap sabihin kasi kung okay lang sa amin dahil nga kahit yung publiko mismo marami nagsasabi na bakit yung ibang senator judges parang yung mga, kung magtanong ay parang mga prosecutor at parang tumutulong dun sa prosecutors. At kung tatandaan lang natin ang talagang obligasyon ng mga husgado ay maging impartial. So,
well, kailangan balikan natin rin ng Senate rules, no? Nakalagay naman sa Senate rules on impeachment na pwede magtanong ang mga senator judges kung lalong ito'y magpapalinaw kung ano talaga ang katotohanan.
Okay.
So, importante po yan. Pangalawa, Ang gusto ko nga sabihin, may bago yatang meaning ang salin eh.
Ano na po yun?
Sekreto ang laman nito.
Okay.
Ang haba-haba ng prosesyon sa simbahan rin po ang dating.
Okay.
Nilabas na rin naman itong salin na ito. Dapat nung una pa eh.
Pero
Ang
parang-
mahalaga, lumabas na.
Pero today, Congressman, makakaasa na mas detalyado yung magiging ebidensya.
Hopefully.
Alright, maraming
Thank you very
salamat.
much.
Congressman Erin Tañada, spokesperson po ng prosecution, at Attorney Jimeno naman po, spokesperson naman po ng depensa. Maraming salamat sa kanila.
Maraming
very
salamat,
much.
Nikki, Mark,
Salamat.
and Karen.
Even the spokesperson are civil. Doon sa simula, nakikita natin yung video, no? Yung lead prosecutor, si lead defense naman, nagkakamayan.
Cuevas at yung prosecution nagkakamayan sila. So hindi hostile yung
Oo,
yung
decente.
Decente, very civil sila, decente, no.
Oo, ngayon, Nikki, meron tayong mga kababayan na nais din magpahayag ng kanilang mga opinion sa nagaganap.
Maganda yung paglilitis. Sana tuloy-tuloy nila yon para lahat-lahat tayo pantay sa batas.
I think it will be a good exercise for democracy because it gets to the policies and processes are going to be practiced.
Ang epekto siguro para sa akin sa judiciary system magkaroon ng malaking sigalot dahil mismong yung Chief of Justice ang nai-impeach. So parang lalabas na baka wala ng tiwala ang taong bayan.
Maapektuhan yung ating judiciary, no? Yung judiciary natin sa judicial system, malaking epekto niyan kasi unang-una, maaring hindi na meron ng tiwala ang ibang tao sa judicial system natin.
Sino? Si Von na. At punta naman natin si Von Aquino na nandyan sa labas ng Senado. Von?
Yes, Nikki, nandito nga kami at in-interview namin si Senate Sergeant at Arms Jose Balahadia. At sinabi niya nga na na-identify na nila yung may-ari ng itim na bag kanina na in-inspection ng SWAT. Sir, live po tayo sa PTV4. Sir, ano po ang assessment nyo dun sa kanina naiwan na bag?
Okay, yung naiwan na bag, by the way, na-identify na namin yung tao. Alright? And I'm not saying that he belongs to a certain organization. Okay? Siya po ay na-identify namin, meron siya pong ID, yung mukha niya maliwanag po sa CCTV namin. And sinabi ko na sa inyo kanina na ang nakita namin sa loob ay media cables. Merong tripod, media cable. So, ang assessment namin is, it's not really a security nightmare, as you might say. It's just perhaps, alam mo kasi ang tao, human beings, sometimes they forget a lot of things, you know. Especially during these times when everything else is up high, dahil nga dun sa impeachment, baka nakakalimutan lang niya, baka nagpunta lang to relieve himself.
Sir, kailan niyo po in-inspection yung baggage?
Kanina. Siguro mga oras, mga 12 o'clock.
So, sir, sa ngayon wala naman pong security threat dito sa paligid ng Senado?
Well, yeah, I've always been saying that. Wala kaming security threat. Kung ano man to, human frailty ito. No? So, ganun lang.
Thank you, sir. Back to you, Nikki.
Okay, thank you very much, Von. At yun nga sinabi, hindi bomba yung laman nung suitcase na naiwan dyan kanina.
At hindi po yun sa grupo namin.
Hindi yun sa atin. No? Kasi ang laman cables, TV cables at saka tripod. Pero hindi po yan sa aming grupo dito sa PTV, hindi po.
At sa puntong ito, Miss Nikki, napakapala din po nating makasama dalawang leader po sa kanilang larangan. Ito pong isang talagang mover in our society. Siya po ay part ng black and white movement, Miss Lea Navarro.
Good afternoon, Mark. Good afternoon, Nikki.
At syempre, yung ating suki.
Suki natin dito, si Dean Amado Valdez, ang presidente ng Association of Law Schools. Magandang hapon po.
Nikki, Mark, Leia, good afternoon.
I'd like to get the assessment of Dean Amado Valdez dito sa naganap kahapon, dito sa Senado. Ang daming nangyari, no? Although napatagal ng konti, pero maraming lumabas na mga bago, no? Tell us your assessment.
Well, it's moving forward at hanga ko doon sa leadership ni Senate President. Otherwise, bedlam na yung hearing, ano? Ngayon, as far as the progress of the presentation of the evidence is concerned, okay naman sapagkat what's important is pumapasok yung mga evidence. In fact, yung statement of assets and liabilities, ito na yung one-half ng ebidensya. In terms of quality, this is the point of reference. Kung pupunta ka sa Lawag, for example, meron ka ng roadmap.
Ito yung kilometer zero.
Meron ka ng statement of assets and liabilities, and everything that you will be presenting will be seen in regard to that statement of liability.
Kay Ms. Leia naman, Ms. Nikki, ano ang from the perspective of civil society, how are you finding the progress of the impeachment trial?
Well, I think satisfactory naman. Ayaw naman natin na bilisan masyado, no, ang proseso dahil kailangan busisiin, no, lahat ng ebidensya. Of course, although we are supportive of the prosecution coming from the Black and White Movement and Bantay Gloria Network, we understand what it may be like to be in a different stage, so to speak. No? I will also speak as once being a performer. No, when you're under on a new stage, things may be a little how do you say, nerve-wracking. You have a bit of jitters, and we're really happy that we seem to see that the prosecution is gaining steam, gaining confidence. They have quite a few, how would you say, very strong opponents in the defense. But because of the leadership of the Senate President, because of the questions being posed as well, the interpellations being expressed by our senator judges, things are slowly coming to light. Discovery is a good thing, and from here today, we're hoping na mas marami pang lalabas na ebidensya at napatungong katotohanan.
Ano yung nakikuha niyong reaksyon mula dito sa mga miyembro niyo pag pinapanood nila?
Siyempre, nervyos kami lahat. I mean, honestly, and so I think are the rest of the people watching. Parang ito ang pinaka teleserye ng lahat ng teleserye.
Nervyos po siguro nagsimulang magdebate na si Justice Cuevas at napakaganda ng kanyang mga punto.
Yes, actually, we have to see, this is an education for all of us.
That's right. At meron kaming nakakalap na mga komento, especially mga law students, lawyers, they're saying din na valid yung mga objections ni Associate Justice Cuevas. Anong tingin mo dun sa legalidad nitong nangaganap and where Justice Cuevas might be coming from?
Marami kasi sa mga objections, siguro one thing here is look at it in terms of ano ba yung strategy ng defense. Ang nakikita kong depensa lang ng respondent ni Chief Justice is pure denial. And then ipe-present niya yung sarili niya. Nakita ko na yung strategy at the start of the hearing that he will be projecting himself to be on a high moral ground. Kaya sinama siya dun Nung first day, usually, hindi naman siya required So he was there in order to say with his actions na wala akong tinatago. I can look at you straight in the face and kaya andito ako. So they were trying to establish high moral ground. Plus pure denial na yan. And then they will just project that the motivation here is personal on the part of the President. So, yan ang totality ng strategy. Ngayon, in order to make that stick is to prevent the truth from coming in. Kaya they will be coming up with a lot of technicalities. Kaya lahat ng mga objections are all based on technicalities.
But I also noted na, well, your lawyer, ako hindi po, pero na-notice din ako na during yung sagutan with the Senate President, with the presiding justice and the defense, parang yung defense, nagpapaano sila na puro rule of law, we must follow it in criminal litigation, ganito yun. Pero apparently, an impeachment court is not that kind of a court, di ba? Mas may latitude yata na hindi kasing stricto para lumabas. Kaya more things can come out, mas makikita yata ng tao imbis na being
And I'll be 200% sure na ang magiging broken record dito na technicality na i-raise nila yung it's not alleged in the complaint. It's not wala sa complaint yung sinasabi nila.
Yung during the impeachment of President Estrada, the Court of Public Opinion took over.
Yes.
Kumbaga parang nanaig yung Court of Public Opinion. Ngayon, sa puntong ito, where is the Court of Public Opinion? Nasaan yung ating mga kababayan sa kanilang assessment sa nagaganap?
From what I understand, at the start, before all of this began, malaki ang porsyento ng ating mga taong bayan ay nagsasabi, naku, guilty yan. Pero ngayon, I think, kailangan buksan muna natin ang ating mga, let's open our minds, tingnan muna natin yung ebidensya, how it's coming out. I think people are beginning to be even more interested and they will now suspend maybe yung kanilang personal opinions to see how things go, because this is really a 50-50 how do you say, chance, no? That the defense will do well or the prosecution will do well. Obviously, those of us who are biased and hoping for a conviction are rooting for the prosecution to do very well, and those also on the other side. But what is beautiful about this process is that you can't win everything every day. You can't, every side will score points. But what is most important to look forward to is how the senator judges will view all of this, and in the end, how they will vote.
Yeah, people are also looking at how they will vote, ano?
Yes.
Parang hindi lang ang gina-judge dito si CJ Corona, kundi pati itong mga senator judges, ano? But yung katanungan din ng iba, what will happen, no? Kung sakali na ang decision hindi i-convict si Corona, what then? When we see in the surveys na parang medyo biased towards the prosecution yung taong bayan, anong mangyayari?
Alam mo, dapat we have to consider it premature pa yan, ano? In fact, we don't want na the streets will decide. Ayan na natin ang impeachment court ang mag-decide dyan, regardless of the decision, kailangan sigurong tanggapin. But we have to exhaust all our wisdom, energy, and resources para ipakita kung ano ba talaga itong case na ito, so that magkaroon ng informed decision, not just the judges, but also the public.
Pero ito bang lahat ng madesisyon nandito o ilalabas dito, maari bang gamitin ito sa ibang korte para i-try si Corona?
Well, sige.
From what I understand, miski kung magko-convict siya sa isa lang ng walong artikulo, he will be removed from office, diba? And that's it as far as the trial is concerned. But I believe it also opens the door for criminal cases to be filed. My question is lang, will it be on what he was convicted on, or on all the other articles?
Or evidences yung mga...
Alam mo, problema dito is the Chief Justice, unlike the President of the Philippines, na may immunity from suit. Kaya parang inopen mo na yung genie dito when you file this impeachment. Yung tinatanong mo na, afterwards, ano mangyayari kung ma-acquit siya? There is already big baggage and damage on the part of the Chief Justice. I think the option on the part of the Chief Justice kung ma-acquit siya would be siguro to free the Supreme Court from the baggage. Kasi may trauma rin ito eh. Alam mo, yung trauma, maski physically, pag nasaktan ka, maski magaling ka na, there is still the pain, ano. And he will be haunted by this. Lalong-lalo na kung ma-prevent yung presentation of evidence pero ill-gotten pala, this will not prevent anybody from filing a criminal case against him sapagkat wala naman siyang immunity from suit. Ngayon, I don't believe na hindi tatanggapin na impeachment court naman yung mga ebidensya sinasabi sapagkat yung Article 2 lang is, the wording is failed to make a public declaration ng kanyang statement of assets and liabilities.
For the title.
Ngayon, kung very, very technical ka dyan, you are referring to the form which is yung papel na hindi mo din. But the spirit of this Article 2 is to make a public statement, yung mga assets niya, and the vehicle, formally the vehicle, to state that it's through his statement of assets and liabilities. Pero alisin mo yung tinatawag na statement, which is a technical term. As a technical term, statement of assets and liabilities, yun nasa Republic Act yun. But as a general term na yun ang inaintindihan ng public, which is what is this, which is political proceeding. Yung statement na yun, yung i-state mo, sabihin mo, ilista mo yung mga assets and liabilities mo. Kung wala doon sa binigay niya listahan, that's still acceptable na pwede mong tanggapin sa impeachment court because it's still in the articles.
Talagang yung education benefit.
Yung
education benefit din for all of us, napakaganda po.
This is how they should explain it. Dapat i-explain ng prosecutor in that manner sapagkat it is the intent. In fact, sa rules of court, meron such thing, alam ni Attorney Marcian, na you can amend the pleading kung ano yung ebidensyang na-submit as long as it is consistent with the spirit of that pleading.
Naku, mukhang ganadong-ganado si Dean. Ang sarap ganun.
Kasi nakikinig ako kanina, but I was waiting for them to make that argument.
Ang na-observe na iba, na merong mga cringe moments nga na medyo hindi ganun kagandaan. But on the overall, sa tingin natin, when the US went through an impeachment of the former President Bill Clinton, nagtuloy yung buhay nila and they all matured. Sa tingin niyo po ba, ma'am, we will all benefit from this? At kung matapos ito, we will all come out more politically mature.
Apart from just being politically mature, I think mae-edukado tayong lahat or mai-inform tayo na hindi lang ito issue na malayo sa bituka. Maraming nagsasabi kasi the man on the street is saying, oh, wala naman ang connection sa akin yun. Meron eh. Kasi pag naalis natin ang korupsyon, no? If we make sure na matatakot ang ating mga opisyal at sasabihin natin, oh, we're watching you, no? Huwag kayong mangurakot. That means mas maraming perang gobyerno, mas maraming serbisyo, mas maraming trabaho. These things always have, may domino effect din ito. And hopefully, we will have better public officials from this.
Nais kong tanungin lang si Dina, no? Kasi kahapon, many raised na points si Senator T.G. Ginggona about itong Supreme Court not being a co-equal body of this impeachment court, no? Although, kasi nga sinabi ni Vidal na co-equal ang Supreme Court at saka ang Senate, no? Pero in this case, sabi ni T.G. Ginggona, hindi. Can you explain that?
That's good.
Outside kasi nung concept nung tripartite system of government, impeachment court, yung tinatawag na co-equal, coordinate, etc. This applies to that system of three branches of government na legislative, executive, saka judiciary. But outside of that, meron yung specific provision na impeachment court. Kaya sinasabi nila sui generis na it's a class by itself. Hindi kasama sa application yung co-equal. In fact, it's superior. At ang mas superior dito sa impeachment court yung taong bayan. Kaya nga you cannot appeal to the Supreme Court sa decision ng impeachment court sapagkat ang appeal niya sa taong bayan na. If you remove Corona unjustifiably, he can go to the people and make his case to the people. In fact, may mga instances sa US, meron yung isang justice na na-remove na-impeach at na-remove ng impeachment court. Nagkandidato siyang House of Representatives. Nanalo siya. So he brought his case to the people, nanalo siya, he was justified. Yun ang appeal. sa impeachment court.
In order for this to work though, sir, kailangan yung both sides nga medyo maganda yung kanilang performance. At moving on to the fourth day, medyo technical yung mga gaganap ngayon din dahil magpapresenta na mismo ng maraming ebidensya. You think the prosecution can perform better on the technical aspect of this trial?
Sa akin, maski kumbaga sasakay sila sa kalesa o sasakay sila sa Jaguar, basta makarating doon sa pupuntahan, pareho lang sa akin eh. Kung nakasakay sila sa kalesa ngayon, pero makakarating din doon sa pupuntahan, okay na sa akin yun. Yan ang hinahanap lang ni Leia eh, di ba?
So, alam mo, ang feeling ko talaga, may faith talaga ako na a conviction will happen. Because our prosecutors are just as passionate about it. As someone said, you can prepare all you want for the war, but it is completely different once you engage in battle.
Okay, thank you very much, Dean Amado Valdez and Ms. Leia Navarro.
And Ms. Nikki, napapanood natin sa ating screen ang pagpasok ng ating senator judges. Naglalakad din sila patungo sa kanilang mga upuan. And as we have observed in the last 3 days, yung pong mga seremonya na pagbang ng gavel, pagdadasal ng isa sa mga senador at pagsimula na ng majority floor leader.
Chief Justice Renato Corona of the Supreme Court is here by call to order. We shall be led in prayer by Senadora Cayetano.
Let us put ourselves in the presence of the Lord. Dear Lord, as we begin the fourth day of the impeachment trial, we thank you for your blessings and turn to your word for guidance. In Deuteronomy chapter 16, verses 19 to 20, you say, "Do not pervert justice or show partiality. Do not accept a bribe, for a bribe blinds the eyes of the wise and twists the words of the innocent. Follow justice and justice alone, so that you may live and possess the land the Lord your God is giving you." Lord, allow us to reflect upon these words and be guided in all decisions that we make today. In Jesus' name, amen.
Amen. The Secretary may now please call the roll of senators.
The Honorable Senators Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revillas, Soto, Trillanes, Villar, the Senate President.
With 13 senators present in the chamber, the chair declares the presence of a quorum. Majority floor leader.
Thank you, Mr. President. May I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms may proceed.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority floor leader.
Mr. President, I move that we take up at a later hour the journal of the January 8, 2012 proceedings of the Senate, sitting as an impeachment court.
Is there no objection? The motion is approved. The Secretary will please call the case before the Senate, sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Majority floor leaders.
Mr. President, may we ask the parties and or their respective counsel to enter their appearances?
Mr. President, ladies and gentlemen of the Senate, good afternoon. For the House of Representatives prosecution panel, same appearances, Your Honors.
How about the defense?
Mr. President, the same counsel for the defense enters its appearance as counsel for the respondent, Your Honor.
Make of record the appearances.
Mr. President,
Majority Floor Leader.
we are now ready for the continuation of the presentation of evidence by the prosecution on Article 2 of the Articles of Impeachment.
Is the prosecution ready?
Yes, Mr. President, we are ready.
Please proceed and call your witness.
Yeah. We're calling our first witness for today, the Register of Deeds of the City of Taguig.
Let the witness prefer to take the witness stand, and let the secretary, the clerk of court administer the oath.
At hinihintay natin itong pag-enumerate ano yung mga ilalabas na mga na-mark na kanina tsaka yung mga testigo, no? So, ebidensya na, exhibit kaninang umaga.
So, suspended until the witness enters the room.
Sinuspinde ng ating presiding officer yung session habang inaantay na pumasok sa session hall yung mga witness. And as always, nagsisimula yung session sa pag-enter ng appearance ng mga abogado ng bawat panig. Kaya,
At apat daw yung testigo ng prosecution at maring more than 4, but initially sabi ni Deputy Speaker Erin Tañada, 4 yung ipipresenta nila ngayon na magpapatunay dito sa mga deeds of sale ng mga properties ni Chief Justice Corona.
kahapon, 2 lang po tayo, inabot po tayo ng alas 7, pero dahil sa mga direction or sa directives kahapon pala na mag-pre-mark, marahil ay bibilis ang proseso ngayon. Para tulungan tayo, Miss Nikki, na maintindihan ang mga kaganapan sa araw na ito, yung ating mga suking legal consultant and analyst.
Kasama natin si Attorney Manix Manalo at Attorney Joey Bernabe. Magandang hapon sa inyo.
Magandang hapon.
Thank you. Do you expect this process, this trial, to be a lot faster today, Attorney Joey?
Siguro in terms of dispensing with the marking of exhibits, which took a bit of time yesterday, maybe this portion of the trial will be more facilitated and will be conducted more promptly, no? Pero tungkol naman doon sa outstanding substantive issues tulad ng allegation of ultimate facts na kine-question ng defense tungkol dito sa articles of impeachment, palagay ko magkakaroon tayo ng medyo masalimuot na debate.
Kagaya kahapon, yung isa pang witness si Marianito Di Maandal ay talagang kinwestiyon ni Cuevas patungkol sa original ba yan? Can you explain to us, yung hawak kasi, sabi, authenticated niya yon. Pero sabi, it's a copy of the original. What is the difference between yung authenticated lang at yung original?
Lalabas yung ganong klaseng issue kung halimbawa ay merong iisa lamang kopyang pinirmahan yung let's say yung affiant o yung tumestigo o yung sumulat ng kanyang lumagda ng kanyang pirma, no? At nagkaroon lamang ng photocopy nung itong original na to. Pero sa pagtatanong ni Senator Kiko Pangilinan, parang ang lumalabas naman yung mga kopyang dineposito sa kay Mr. Di Maandal ay multiple copies ng
original.
Each of which is originally signed
Ayun.
by Chief Justice Corona.
May bearing ba kasi yon? Bakit anong importansya nun?
Kasi kung bawat isa doon ay pinirmahan niya sa original, ibig sabihin bawat kopya ay original.
Kung pinag-uusapan dokumento, Ms. Nikki, tanong natin kay Attorney Manix para ma-educate ang ating mga viewers, sino ang may karapatan na mag-testify on a document or mag-prove ng isang dokumento?
Depende, no? Yung kahapon kasi, ang pinag-uusapan doon, it's a public document, no? So, ang ang isang pinakamagandang pwede na magtestigo on its authenticity and validity would be the custodian of that public document. In that case, it was our witness, si Mr. Dimaandal, na obviously, yun yung trabaho niya sa Malacanang, tagatago ng mga sound. No? So, nung pinesenta siya kahapon, ang tanong lang sa kanya una kasi medyo nagkamali on how the answer was drawn out, no. So ang lumabas na sagot sa kanya a copy of a copy.
Nalito.
So hindi siya certified copy of an original. Kaya nga tama yung sinabi ni kasama natin Attorney Bernabe na yung pagtanong ni Senator Pangilinan na
nalinaw.
Ayun pala, pro-original yung nasa kanya.
Ngayon, bakit may markings in bawat certain portions of the documents? Bakit kailangan pa ng ganun?
Yung markings kasi, that's used for reference to aid the judges actually. When the time comes all the evidence is submitted or formally offered as evidence on behalf of one of the parties, yun yung titingnan ng judge kasi kung let's say you're saying something about a certain element of the course of action.
Naglalakad na, Nikki, ang unang testigo sa day 4 for the prosecution.
Do you swear to tell the truth and nothing but the truth in this impeachment case of Justice Renato C. Corona?
Yes, ma'am.
So help you God.
So help you God.
Your Honors, to conduct the direct examination is Congressman Barzal.
Please let the witnesses state his personal circumstances for the record and qualify.
Mr. Witness,
Sir, Your Honor.
please state your name, age, and other personal circumstances.
I am Attorney Randy A. Rutacio. I am the Registrar of Deeds of Taguig Pateros.
May we formally offer the testimony of the witness, Your Honor. The witness will testify that he is the Register of Deeds for the City of Taguig. He will also testify that he came to this court by virtue of a subpoena issued by the Honorable Impeachment Court. He will also testify that pursuant to this subpoena, the documents indicated therein were brought by him. He will also testify with regard to his principal duties as Register of Deeds, and finally, he shall identify the documents which he shall present.
Proceed.
May it please the Honorable Court. Mr. Witness, you stated a while ago that you are the Register of Deeds for the City of Taguig. Could you please inform
Yes,
us
Your Honor.
what are your principal duties and responsibilities as Register of Deeds for the City of Taguig?
Your Honor, sir, we are the custodian of the records of the land titles in the city of Taguig and Pateros. We are also mandated by law to register all documents affecting the lands therein.
Well, Mr. Witness, could you please tell us the reason, if any, why you are present this afternoon before the impeachment court?
I was subpoenaed, sir, by the impeachment court to testify and to bring documents.
You stated that you were subpoenaed by this impeachment court for today's hearing. Do you have a copy of that subpoena?
Yes, Your Honor. I will look for it. Please excuse me because I have many documents here. Inayos ko na ho kanina ito. But because of the marking, we have, please excuse me because we had markings of the documents and
The subpoena issued by this court required you to produce certain documents. Did you bring the documents with you?
Yes, Your Honor.
And they're in your possession right now in the courtroom.
Yes, Your Honor.
Please, counsel, present them properly for the record.
Okay. In the subpoena issued by this honorable impeachment court, in number
Excuse
one...
me, sir. I have the subpoena right now in my hand. Thank you.
In the subpoena which you have given to this representation, in number one, letter A, you were required to present CCT number 5582 in the name of Cristina R. Corona, married to Renato C. Corona. Do you have a copy of this CCT number 5582 mentioned in 1A of the subpoena?
Yes, Your Honor. I have this document, sir. It was subpoenaed to be brought here before the court.
Is that document the original TCT in the Registry of Deeds or a verified copy?
May I continue, Your Honor?
Please.
You have presented to this representation an original copy of condominium certificate of title number 5582. Did you bring any photocopy of this condominium certificate of title number 552? 5582.
Yes, sir. I have brought a photocopy of the condominium certificate of title number 5582.
At this juncture, Your Honor, I earnestly request the counsel for the defendant to compare the Xerox copy, the photocopy which was presented to me, as compared to the original in order to make a stipulation whether or not the photocopy represents a faithful reproduction of the original.
The counsel for the defense may do so if he wishes to enter into a stipulation of fact.
Attorney Montano Isguera, Your Honor, a member of the defense panel, is examining both documents. Your Honor, please, Mr. President, we wanted to state for the record and for the expediency of the proceedings being undertaken by this impeachment court, that if the purpose of comparing the two documents is to effect a substitution, may we ask that the substitution be made later, Your Honor? Because we will be dealing with so many documents, then every document, Your Honor, will require some time for purposes of comparison, comment, and so on. But if the totality of all the documents are already marked and identified by the witness, then we can make the comparison later, Your Honor.
Thank you very much for that manifestation.
What is the pleasure of the prosecution?
Well, considering the manifestation made by the defense counsel, I am withdrawing my question with regard to the stipulation regarding whether or not the certified true copy is a true and faithful reproduction of the original. I would proceed with my subsequent questions, Your Honor.
Proceed.
Well, could you please, this honorable court, what document did you rely on for the issuance of this condominium certificate of title number 5582?
No basis, Your Honor. There is no statement on record by the witness that it was he who made or who drafted the document. All that the witness stated before this honorable court is that he brought the document, subject matter of the subpoena to the STECOM.
I will reform the question, Your Honor. Mr. Witness, a while ago you stated that you are the Register of Deeds for the city of Taguig. And you also stated that one of your duties is the issuance as well as possession of certificates of title with regard to lands or condominiums situated in the city of Taguig. Right now, you have presented condominium certificate of title number 5582. Could you please tell us the reason, if any, why this condominium certificate of title number 5582 came into existence?
Not within the competence of the witness, Your Honor. In the narration of his functions of his office, Your Honor, there is never any statement to the effect that it is he who is responsible for the issuance, preparation, and drafting of this document, Your Honor. All that I recall the witness having stated is he has in his custody the documents required by the subpoena. So no basis, Your Honor.
I'll report again the question to satisfy the curiosity of the defense counsel.
It is not my curiosity. That is what the law provides. You're not...
I'll reform the question, Your Honor.
Avoid personalities. Just lay the basis. What is the basis of the possession of the register of deeds of that CCT?
Can I ask the question?
Yeah, proceed.
Okay. A while ago, you mentioned that you came to this court by virtue of a subpoena.
Yes, Your Honor.
In paragraph 2 of this subpoena, and I read, original and or certified true copies of all documents pertaining to the acquisition, disposition, ownership, or enjoyment of the properties covered by the above listed TCTs and CCTs, including but not limited to the following: deed of absolute sale, deeds of conditional sale, deeds of donation, deeds of assignment or transfer, contracts of lease, certifications authorizing registration issued by the Bureau of Internal Revenue, and other documents related to the foregoing. My question is, did you present any deed of sale? Did you present or did you have right now any deed of sale as required by the subpoena?
You mean, Your Honor, that if he has in his possession? Because the witness being asked, did you present? There is no presentation.
No, not yet. I will draw that. If he has in his possession right now, pursuant to the subpoena.
Thank you for the clarification, Your Honor.
The witness may answer.
Yes, sir, I have it in my possession.
I think this court can take judicial notice of the fact that we have a condominium law and that it is required that titles to condominium units are being registered, and the registration is effected upon the presentation of a deed of absolute sale of a condominium to a particular party for registration.
Yes, Your Honor. Kasi I'm trying to verify whether this the sale, the deed of sale which pertains to that, because I have in my possession about a number of deeds of sale.
I don't know. So what? Witness examining the documents in his alleged possession, Your Honor.
You must forgive me, sir, because we have it in
No,
marked.
I'm just making
so
that of record.
Thank you, sir.
I'm not commenting on what you're doing.
Will you please repeat your question, sir?
May I suggest, for an orderly presentation of the evidence, that you mark as for purposes of identification the documents pertaining to that title in sequence. The deed of sale, if there's a deed of sale, then the corresponding.
Yes, Your Honor, we have done that.
No, I'm
previously,
addressing
sir.
this to the to the counsel for the prosecution.
We would like to manifest, Your Honor, that there has been already a pre-marking.
So will you kindly proceed and identify the documents supporting the CCT register and finally the CCT?
Here is the deed of absolute sale regarding the Fort Bonifacio Development Corporation, sir.
Deed of sale of the selling corporation and to whom?
Yeah, this. Please repeat your.
Trial suspended for 1 minute so that you can prepare. The chair would like to go to...
Okay, sinuspindi po itong proceedings muna habang inaayos pa, no? Bakit nagkakaroon ng problema dito sa... Parang napakasimple lang, just to present the CCT, ano? You have to establish, what do you have to establish to make sure na ito nga yung CCT and this is really a CCT? Bakit ganon?
Well, kanina napansin natin yung sa pagtatanong ni Congressman Barzaga. I'm sorry. Na he wanted to find out kung ano yung basehan ng pag-release ng CCTC, no? Obviously,
Wait,
nakita natin...
CCT is Condominium Certificate of Title. Okay, sige.
Okay. Anyway, nakita natin na nag-object si Justice Cuevas dahil sabi niya nga, wala pang basihan yung pagtatanong mo sa whether there was a deed of sale or not, no? So, medyo nagkaroon ng konting guluhan. Pero eventually nakuha na rin naman yung sagot na may deed of sale nga. And therefore, I'm sure yung susunod na tanong doon will be directly on the deed of sale.
Mukhang sa tingin mo, Attorney Joey, medyo mas handa ngayon yung nagde-direct examination.
Well, siguro kasi noong unang araw na tinawag si Congressman Barzaga para mag-present ng ebidensya or ng witness, medyo nagkaroon ng konting aberya. Kaya siguro nitong susunod niyang pagkakataon, hindi naman niya sinayang ang oras para siya ay maghanda ng wasto para dito sa parte ng trial natin.
Pero supposedly na-mark na itong mga ebidensya ito kanina umaga, no? Pero hindi kahit na na-mark na pala, it doesn't mean na talagang natanggap na, no? We see Jinggoy Estrada reading evidence in action, no? Nag-aaral sila habang
hindi po inaaral ng mga senador, hindi kailangan sa senador, pero para po for the purposes of this trial, mukhang they're brushing up on law. Ano po? Tanong ko kay Attorney Manix, bakit importante yung deed of absolute sale sa diskusyong ito? Bakit hinihingi pa yung pinanggalingan ng titulo?
Well, una-una kasi, yung, under yung rules natin sa Registry of Land Titles, let's say may pinanggalingan na titulo yan na dati, bago ma-transfer yung title yun sa ibang tao, kailangan may basihan yun. No? Kaya nga kanina, nakita nyo dun sa subpoena, pinapaproduce kung meron man deed of donation, deed of assignment, deed of sale. So I guess in that particular title na pinapasagot doon sa Register of Deeds, may deed of sale na involved, no? I guess from the developer, pagtayo nila ng building, to the buyer. So, kailangan nila pakita yung deed of sale para mapatunayan na valid yung titulo.
At binili niya.
At binili.
Hindi dinonate.
At dito lalabas ang anong impormasyon na mahalaga para sa proceedings na ito, Attorney Joey?
Well, ako ang una kong naiisip, maaari rin naman na yung pinagbilihan o ang nagbenta nitong property ng condominium unit kay Mrs. Corona ay isang third party rin, ano? Hindi naman natin nasisigurado pa based doon sa diskusyon kung talagang nanggaling pa ito doon sa developer. Pero ano man ang panggalingan nito, ang isang magpapatunay ng prosesong ito ay na merong kakayahan si Mrs. Corona para bilihin itong property na ito.
Dito ba lalabas yung kung magkano ang halaga nung property na yon?
Tama yun, Mark. Doon din lalabas at makikita natin doon sa deed of absolute sale kung magkano ang presyo ng property.
Pero ito yung presyo ng property at the time na binili, maaring maging iba sa present, hindi ba? How do they gauge kung magkano yung actual cost at present nung property na yon as against nung binili niya doon sa deed of sale?
Every year, nagbabago ang valuation ng property. Merong tinatawag na market value, merong tinatawag na zonal valuation, at madalas, halimbawa, for tax purposes, ang ginagamit is yung higher value na nalalaman ng BIR, for example. So, tama ka na maaari na from the deed of absolute sale, hindi malalaman kung ano talaga yung presyo ng condominium kasi let us say na binili yon 10 years ago or 5 years ago, maaaring nag-appreciate na yung value nun.
Malalaman din ba dito kung hulugan yon o cash ang pagbili?
Madalas nakasaad din doon sa deed of absolute sale kung ano yung pamamaraan ng pagbayad. Kadalasan dyan, kung karamihan ng bumibili, ang ginagamit yung tinatawag nating installment payment. Ano?
May down payment,
Yes.
tapos monthly amortization.
Kasi ang kwento ata from the media mukhang hinulugan.
Yes.
So ito mapoprove kung ano talaga, totoo.
Oo, tama yon.
Okay, mukhang itong RD naman ay handa. Ano? Mukhang ready siyang sumagot. Bit-bit niya lahat ang kanyang kailangan dokumentong bilhin. Dali.
Witness handing to this representation a deed of sale dated November 29, 2005, the vendor being Port Bonifacio Development Corporation, the vendors being Cristina Corona, married to Renato Corona. The deed of sale covers a property situated in Taguig, and the selling price
Mr. President, apparently there will be no necessity for this because it is not the testimony of the witness that will enable to identify this property, but the buried document. So the document will speak for itself. They have marked it. Our assumption is they will present it as evidence, Your Honor.
Let the prosecutor present his evidence. Anyway, he's just describing from the document, unless
Yes, Your Honor.
there's an indication of variance of his description with the contents of the document.
Thank you, Your Honor. What I just wanted to object is the time consumption, Your Honor, because the identity of the document is mentioned in the document itself.
I leave it to the prosecutor to present his case.
Thank you, Your Honor.
Thank you very much for that very grateful allowance coming from the Senate President. May I just make it of record, Your Honor, that actually why we have some trouble insofar as arranging the documents are concerned, I was informed by the city assessor that before the start of the trial, by the city register of deeds, that before the start of the trial, he was required to have his documents be photocopied. And therefore, he was not able to arrange it properly in order to have a systematic presentation of his documents.
Correct. Normally, in the ordinary course of business, the registerable document is the deed of sale, for which the CCT is issued. And that's why I was suggesting that you follow the order of the sequence of evolution of titling. So proceed.
Well, aside in the subpoena, it is also provided for you to present the CCT number 164-201-00062 in the name of the spouses Cristina Corona and Renato Corona. Do you have the original of that CCT?
We have the certified copy of the CCT, sir.
Where is the original?
The original is not required anymore, sir, because we are under the computerized system of land registration already.
It is in the possession of the land registration office.
Actually, sir, it is stored in our database.
Correct. But it's still in the possession of the land registration office.
Yes, sir.
Under the responsibility of the land registration office as a custodian.
Yes, sir, but there is no physical title anymore under the land
Because
registration
it is
system.
computerized.
Yes, sir.
Now, for clarification, who did the inscription of the original title in the computer?
Our office did, sir, because we are the ones who are processing in the Registry of Deeds of Taguig, where the title is, where the land is located, where the lot is
Who
located.
did the inscription into the computer of the original title?
The encoder, sir, the encoding clerk, sir, because it undergoes a process from the entry and to the payment of the fees and to the encoding clerk and then to the
Can
land
you describe
registration.
to us the manner by which the title, a condominium title, reaches your computer system, so that we will understand? The public would like to understand this.
Yes, Your Honor. Ordinarily, a deed of sale is presented to us for registration by any one of the parties. And then...
Normally, the one that presents to you is the buyer.
Normally, sir, it is the developer in our case, sir.
Huh?
The owner of the condominium corporation, usually.
Okay. Yeah.
And then after that, our registry information officer goes through the documents, and then it is referred to our entry clerk. And when the documents are in order, she processes it, and then it goes to our cashier, so that the payment of the required fees for the government will be paid. And after that, the cashier gives it to our encoding employee, whereby the entries in the sale, in the document, are processed, and after that, it goes to the land registration examiner. And for the examination of the document for propriety, and to see to it that all requirements for registration are present. And after that, sir, it goes to the Register of Deeds for approval and for final examination of the documents and the requirements.
And
after that is approved, it is being printed and then uploaded, meaning...
What is printed?
The owner's copy, sir. The owner's copy of the document.
The title already.
Yes, sir. Yes, sir. After approval, the title...
The title based on the deed of sale.
Yes, sir. Yes, Your Honor.
And it describes the condominium unit titled to the buyer, and that is entered into the condominium certificate of title.
Yes, Your Honor. The details of the registered owner and the area of the lot or the condominium and other pertinent details.
And the condominium, the certificate of condominium title is then entered into your computer.
Yes, Your Honor.
And so therefore, what happens to the hard copy of the certificate of condominium title from whom you copied the data inscribed into your computer? What happened to it? It's given to the owner?
The owner's copy, sir, is given to the owner.
Huh?
The owner's copy of the title is released to the owner,
What
to the buyer.
What is released? The one from whom you copied the data entered into the computer?
Because, sir, when there is a sale or a deed of a conveyance, the name of the seller is already, the title of the seller is already cancelled. And so, ultimately, the certificate of title which is issued is already in the name of the buyer. And that is the title which is released to the buyer bearing the name of the new owner.
What I am referring to is the source of the data that is being entered into the computer. Is it the copy of the held by the condominium owner, or is that an official copy in the possession of the registry of deeds?
Actually, sir, the details in the new title are copied from the old title. The area, what is...
Just a minute, old title?
The title of the seller, sir.
It is from the seller.
Yes, sir. The details, the area, and the other details are
from the old title.
Are from the old, from the title of the seller.
In other words,
sir.
it is likened to the OCT in land titles.
Yes, Your Honor.
All right. Now, then the only variant is the name of the owner, because the old title carries the honor of the developer.
Yes, Your Honor.
And now, when it is sold by the developer, the title of the developer is cancelled, and in lieu thereof, a new condominium certificate of title is issued in the name of the condominium owner.
Exactly, Your Honor.
And the details or data of the old title and the title given to the condominium owner are identical except the name of the owner.
That is true, Your Honor.
And the data encrypted in the computer are the same except for the ownership.
Exactly, Your Honor, sir.
Proceed.
Did you also bring with you CCT number 164 201 000063 in the name of the spouses Cristina Corona and Renato Corona?
Yes, Your Honor.
Do you have a copy of that title right now?
Yes, Your Honor. Zero 0063.
What about a copy of CCT number 164 201 1000064 in the name also of the spouses Cristina Corona and Renato Corona?
We have it in our possession, Your Honor.
What about CCT number 164 201 000065? Also in the name of spouses Cristina Corona and Renato Corona.
Yes, sir, we have it.
Do you have in your possession right now the document which became the basis for the issuance of these titles, starting with CCT number 164-201-000062 up to 65?
The question is, do you have?
Yes, Your Honor. I have the deed of absolute sale.
Can you present the deed of absolute sale right now to this representation?
Yes, sir, I have the original of the deed of absolute sale.
Just for the record, Your Honor, I would be making a brief description of the deed of absolute sale just handed to me by the witness.
Proceed.
The deed of absolute sale pertains to the so-called Bellagio Golf View residences, with Mega World Corporation appearing as seller, and with the spouses Cristina Corona and Renato Corona being the buyers. The subject matter of the sale are actually one tower identified as Unit 38-B, covered by CCT number 19497 with an area of 303.50 square meters. And also, the parking slot with number 50, basement 2, number 51, basement 2, number 52, basement 2, and covered by CCT number 19651 with an area of 12.50 square meters, 19652 with an area of 12.50 square meters, and parking slot number 3 with number 52, basement 2, covered by CCT number 19653 with an area of 1250 square meters. And for the record also, I would like to manifest that the selling price as indicated in this deed of absolute sale is 14,510,225 pesos. And for the record also, I would like to manifest that this deed of absolute sale is dated December 16, 2009. And further, I would like to make the manifestation, Your Honor, that in the SALN, which was presented yesterday and identified, these two Taguig properties were declared for the first time in the SALN of Respondent Chief Justice for the year 2010.
I move to strike out, Your Honor, please. I'm moving to strike out all the subsequent manifestations because these are opinions of the counsel, Your Honor.
And besides, that has to be elicited from
the witness, Your
the
Honor.
witness.
Thank you, Your Honor.
Motion granted.
Mr. Witness.
Just for clarification, one condominium was bought with 3 parking slots. Correct?
Yes, Your Honor.
Covered by separate titles. And all of these separate titles were included in the listing of properties attributed to the Chief Justice. Correct?
Yes, Your Honor.
All right.
You were also required to present or to bring before this court TCT number 989 in the name of the spouses Cristina Corona and Renato Corona. Do you have that TCT?
TCT 87. Ano yun? TCT. Sige, ako lang. Sige, sige. 8. TCT yan, hindi. TCT yan.
May I see the subpoena, sir, please? Because previously I have arranged this and it was complete, but we had these markings this morning.
CCT. Ano naman tinanong yan? CCT to eh. TCT yun eh.
989.
Ito. Hindi.
I have a copy of TCT number 989, sir, but it is in the name of Mega World Corporation, and it is a cancelled title, sir.
You were also required to present TCT number to bring with us.
Just a minute, for clarification. What is that title cancelled? In whose name was it?
For the record, Your Honor.
I think that the question is addressed to the witness, Your Honor.
Yes.
Well, to the witness.
With my apologies.
It is in the name of Mega World. The registered owner is the Mega World Corporation, sir.
And it was cancelled.
It is already a cancelled title, sir.
Do you know why it was cancelled?
I believe it was sold to the buyer.
To the buyer. What buyer?
Sir, may I see the document, please? In our entry number 5459, there is the registration of a sale in favor of a certain Maria Charina Corona. And that is why it was cancelled, sir. It was transferred to...
Yeah, wait a minute. The rest or the subject matter of that title was sold to Cristina Corona.
No, sir. The buyer, in accordance with our record, sir, the buyer is a certain Maria Charina.
Maria Karina.
Charina, yes, sir.
Corona.
Yes, sir. Yes, Your Honor.
And the source of the one bought by Maria Karina's Corona is the subject matter of the cancelled CCT of the CCT cancelled.
Yes, sir. Actually, it is a transfer certificate of title. It refers to a parcel of land owned previously by Mega World Corporation
and sold
to Madam Maria Charina.
And in lieu of the original title in the name of Mega World, what was the title number of the new TCT that was given to Maria Karina Corona.
It was cancelled, sir, and it was sold to Maria Charina Corona, and accordingly, a transfer certificate of title number 2093-P was issued bearing the name of Maria Charina R. Corona as the registered owner, sir.
Maria Charina Corona is the correct name of the buyer. Okay. Mr. Witness?
Yes, Your Honor.
Okay.
Sir.
Let the record be corrected.
May I continue my statement, Your Honor?
Proceed, please.
Well, actually, as I have stated before, all the documents which have been the subject matter of the subpoena had already been presented. Some of the documents had already been pre-marked before today's hearing. Unfortunately, due to lack of time, not all the marking was not completed. And therefore, we would like to manifest that after today's hearing, or before the start of the hearing next Tuesday, we shall continue with the marking of the exhibits, which we will not able to mark this afternoon.
And maybe what the presiding chair would suggest, subject to the conformity of the Senate, is that you make a written record of the markings formally to be presented to this court, so that we will not get lost, and then that will be recorded in the records of the proceeding.
We will do that, Your Honor. That would be all for the witness, Your Honor.
With the conformity of the defense.
Subject to the discretion of this honorable court, Your Honor. We are willing to do that. Now, he is now temporarily closing. Under the ordinary rules of procedure and evidence, Your Honor, we can cross-examine only after the direct examination had been terminated. But in order to gain time...
No, but this is a witness, so since the witness, the prosecution is finished with the witness, it's proper for the defense now to conduct a cross-examination.
Precisely, Your Honor, we will be asking for authority and or permission to be allowed to conduct our cross-examination, Your Honor.
Proceed.
Thank you, Your Honor. Now, Mr. Witness, kindly go over the subpoena address to you before I start asking you questions.
Sir, may I have the document, sir? Thank you, sir.
Kindly examine it before I proceed with my cross-examination. Witness examining the document, Your Honor.
I have examined it already,
All right.
Your Honor.
Now, may I direct your attention to a portion thereof which is then and there to testify your knowledge in the case which is before this Honorable Senate. Did you notice that?
Yes, Your Honor.
Did you understand that you are supposed to testify and not merely bring the documents mentioned in the subpoena?
Yes, Your Honor.
And you are required to testify based on your personal knowledge, I suppose.
Yes, Your Honor.
All right. Now I noticed that in your direct examination, your answers in the direct examination, you mentioned about the procedure relative to the issuance and the cancellation of titles involved in a particular request for registration. Am I right?
Yes, Your Honor.
And am I right to state that you have no personal participation in any of those proceedings? You're not.
Please repeat the question, sir.
Am I right in understanding you that in the presentation, recording, and so on that you describe in your direct examination, you have no direct participation?
Yes, Your Honor.
All right. So you do not know the incidents taking place during the process of registration?
As the head of the office, I have the knowledge of the procedures.
You mean you were present when those proceedings were being undertaken?
Not personally, sir.
Oh, so what is the basis of your knowledge? That which had been reported to you only, is it not?
That it has underwent the process because of the system.
But you are not answering my question. My question to you is this.
Yes, sir.
What is the basis of your knowledge in the process of registration that leads to the issuance of the titles that you brought before this honorable court?
My basis, sir, is there is a process in the registration of the document.
And you just...
And it will not reach the approval stage without going through the regular process in our public documentation.
May we request, Your Honor, that the witness be allowed to complete his answer before additional questions should be propounded?
Go ahead.
Counsel, please let the witness complete.
Thank you, Your Honor. Thank you, Your Honor. May I apologize to the learned counsel for the prosecution. My question to you is, what personal knowledge do you have in the matter of processes involving registration that you describe in your direct examination? Because you made me believe that all these were done by people in your office. Am I right?
That is true, sir.
All right. It is clear now that those proceedings had been undertaken by your people or employees under your command.
That is true, sir.
All right. And what you know about this comes from the report that were submitted to you as head of the office.
Actually, sir, it will, in my previous answer, it will not come to the approval stage without undergoing the usual process of registration, which goes to the entry clerk, the payment of the required fees, and then to the land registration examiner, and then recommending it for approval or denial at my stage, sir.
But that is not my question to you, Mr. Witness. My question to you is your personal knowledge involving the proceedings that were undertaken for purposes of registration.
Yes, sir.
All right.
What I can say is,
Yes,
my
madam.
personal knowledge is that it went through the usual process as mandated in our office. But if what you are asking me, sir, is if I were personally there when it was entered and then when it was presented to the cashier at that time, my answer will be no, sir. Not in all cases.
All right.
But in some cases, I was personally there,
All
sir.
right. Thank you then. Now, among the documents that you identified today, will you kindly point to us where in any of those documents were you present in the entire process of registration of these documents? I suppose none.
Well, I think, Your Honor, that the counsel is giving an answer even before an answer could be made by the witness.
That is part of my question.
No, that's a part of cross-examination.
That's it. Two questions, Your Honor. The question should be made only one by one under the rules on evidence.
What is the basis of the rule of... what is your ground of objection? If Your Honor, please. May I ask the ground of the objection, Your Honor? Because he's already arguing.
No,
what the law provides is state the objection only and do not make an explanation.
My objection is, Your Honor, is that before another question should be propounded, the witness should be first permitted to answer the previous question.
All right, so
That's very basic, Your Honor.
All right,
And
so-
I learned that from my remedial law professor, who happens to be no less than the defense counsel.
Maybe you were absent when I discussed that.
Order. Order.
Sorry, Your Honor. I
So that
apologize.
there will be no wrangling. Will you kindly slice your questions minutely so that the witness will understand?
All right. Thank you, Your Honor. And they shall be followed. Among the many documents that you now brought before this court and identified, which one were you present throughout the entire proceeding?
If your question, sir, is throughout the entire proceedings and in every step of the procedure, my answer will have to be no.
I see. Thank you. Now, so what you wanted to tell the Honorable Court in your testimony a while ago under direct is that those procedures that you identified were the procedures to be undertaken before registration could be effected. Am I right?
Yes, Your Honor.
All right. And with that, you are referring to the legal procedures pertaining to your office. Am I right?
Yes, Your
All
Honor.
right. And you presume that they were followed religiously by the persons under your responsibility or command, right?
Of course, Your Honor.
Yes, sir. All right. Now, may I call your attention to ano itong dokumento? Oo, parking lot. All right. May you kindly go over those documents you identified and kindly tell this honorable court which of the documents pertain to the parking lots insofar as that condominium you mentioned a while ago? At this juncture, Your Honor, if we may be permitted,
proceed.
Apparently, these documents presented in today's proceedings, Your Honor, together with the testimonial evidence of the witness, we are made to believe that this is in support of the paragraph in the impeachment complaint regarding alleged illegally acquired wealth. Under Article 2 of the impeachment.
We have to ask the prosecution the purpose for which this witness is presented, and I think he stated that in the beginning of his presentation. He narrated the purpose for which the witness was being asked to testify.
Your Honor, please, may we continue?
Yes, please.
All right. I was intently listening to the offer of the counsel when the witness before the witness started testifying, and I did not, there was no categorical statement that this is for purposes of proving that aspect in the complaint dealing with alleged illegally acquired wealth. That's why I'm clarifying now, Your Honor, because...
That's correct. We can appeal to the record. I think you're correct that he did not state what paragraph this witness is supposed to testify on.
Because I'm very sure, Your Honor, this is no longer in connection with the SAL, which was alleged in the earlier testimony of the witnesses that were presented, but rather a different aspect of the impeachment complaint, and that is the alleged acquisition of illegally acquired wealth. Now, we made this manifestation, Your Honor, because we have a standing objection insofar as this, and that was noted by Your Honor in the records of the case.
That's correct.
Now, our point is this: is there any compliance with the rule of pleadings and procedure that will warrant introduction of evidence in this particular issue? Our answer is none, Your Honor. Why? Because may we be allowed to go a little further, Your Honor. paragraph 2.4, Your Honor. And with the permission of this honorable court, may I be allowed to read. Respondent is likewise suspected and accused of having, allegedly acquired ill-gotten wealth, acquiring assets of high values, and keeping bank accounts with huge deposits. It has been reported that respondent has, among other things, 300 square meter apartment in a post-mega world property development at Port in Taguig. Has he reported this as is constitutionally required under Article 11, Section 17 of the Constitution in his statement of assets and liabilities and net worth? He is no longer testifying of the alleged son of the accused, Your Honor. Now, I said, may I be allowed to go a little further, Your Honor? I said that there could be no evidence that could be admitted in connection with this because there is no valid allegation of a cause of action. Why? The allegation is suspected of acquiring. Mere suspicion does not suffice. The rules of pleadings, Your Honor.
Just to clarify,
Yes,
Counsel,
Your Honor.
are you disputing the ownership of the 300 square meter apartment in Mega World, supposedly owned by the respondent?
May I now answer, Your Honor?
Yes.
I have not gone that far, Your Honor. My point is this. There can be no offer, much less any reception of evidence on this particular allegation, Your Honor. Why? Because there is no compliance with the rules of pleadings. And if there is none, then there could be no evidence that could be presented in support thereof. The entire complaint is a nullity, no cause of action, no relief can be granted.
Well,
that is not the statement of Justice Cuevas. That is the jurisprudence on the point, Your Honor.
May I respond, Your Honor?
I'm not yet through, Your Honor.
Yeah. Let the counsel
Yes, Your Honor.
Now, if the purpose is solely to determine whether he has filed Justice Corona had filed his SAL, I see nothing in the evidence now being presented. They were the subject matter of the evidences presented yesterday. We took note of that. But in this particular instance, now how do we determine the sufficiency of an allegation of a cause of action? The jurisprudence on the point say, if on the basis thereof, a plea of guilty in criminal cases or confession in civil cases, there could be a valid judgment that could be rendered against the party against whom the allegation or imputation had been made, that there is a valid pleading sufficient enough to place the person accused on his defense. Now, my question is this. How could there be a valid judgment when the basis of the allegation is suspicion? Hindi ho ba masyadong we are trying a Chief Justice of the Republic of the Philippines, the highest official in the judicial department of government, on the basis of an allegation of suspicion, and secondly, on the basis of alleged report?
Let us take this one by one.
Yes, Your Honor.
In the case of the 300 square meter apartment, is that included in the SAL end of the Chief Justice?
That was included. In
Yeah,
fact,
so if that is included anyway, that is an admission on the part of the Chief Justice that he owns that apartment.
we have not.
No, I'm just, I'm not saying that we are not talking of offer of proof yet, no.
Yes.
But I'm just saying this. So, as far as this chair is concerned, as far as the 300 square meter plus of apartment is concerned, I think a question regarding this is proper. But with respect to the acquisition of assets of high value and the existence of bank accounts, I agree with you that would be a questionable allegation.
Yes.
So we will deal with that when the offer of proof is reached. At the moment, we are just talking about the documents that were subpoenaed.
with the kind indulgence of the Honorable Presiding
Yes.
Justice. I raised that point, Your Honor, because we are now in the stage of proof and no longer allegation. My point is this: if we follow the pertinent jurisprudence on the point, there can be no proof that could be offered, much less accepted and utilized in deciding this issue on the basis of a non-existent allegation. Because when the allegation is not in accordance with what the law and pleadings require, it is as though it had not been made, nothing exists, no relief can be had thereof. That is my point of objection, Your Honor. I am not questioning their statement relative to 300 square meter condominium, Your Honor.
In fact, there's an admission admission against interest made by the Chief Justice on this, because he admitted publicly that he owned
Yes,
this.
Yes, Your Honor. In fact, if Your Honor will remember, with the kind indulgence of the Honorable Court, we even made that a part of our evidence, Your Honor. But the purpose is not to prove that he acquired, but that he had complied with the requirements of law relative to the filing and submission of SLN. Nothing more. Not on the issue of ill-gotten wealth. Just to make my point clear, Your Honor.
Correct.
Now,
Correct. I agree, Mr. Counsel. What I'm trying to say is, I agree with you that you can register your continuing objection to any introduction of evidence with respect to ill-gotten wealth and with respect to the existence of huge amounts of money in the bank. But that whether we will admit those evidence when they're offered during the period of offer of evidence is something else.
may I now be allowed?
Yeah, please.
With your indulgence, Your Honor. Besides, this witness now is not here only on the issue of subpoena testificandum. Also to testify. That's why, if the Honorable Chairman will notice, I made him read the order for him to appear. Not merely to bring the documents stated in there or described in there, but to testify. And since this will involve testimonial evidence, our law, procedure, and evidence states the moment it is testimonial evidence, right at the first time the witness takes the stand, the offer is already being
Then
made.
you can object to any reference to ill-gotten wealth, and the chair will make a ruling.
Thank you, I was about to raise that, Your Honor, at the start, but fearful of the apprehension that may be generated, that we are delaying the proceeding, we have chosen to keep silent on that particular issue. Thank you very much, Your Honor.
Your Honor, may the prosecution respond?
Mr. President.
Proceed.
Well, Your Honor, it has been always the consistent position of the defense that there is no allegation of ultimate facts. And I read paragraph 2.3, Your Honor, in our complaint. It is also reported that some of the properties of respondent are not included in his declaration of his assets, liabilities, and net worth in violation of the Anti-Graft and Corrupt Practices Act. For us, this is already the ultimate fact. If the counsel for the defense requires us to state the properties which were acquired in violation of the Anti-Graft and Corrupt Practices Act, then the enumeration of these properties would be considered as evidentiary fact. Second, in paragraph 2.4, it is also provided that respondent is likewise suspected and accused of having accumulated ill-gotten wealth, acquiring assets of high values, and keeping bank accounts with huge deposits. That is also an ultimate fact. If the counsel for the defendant would like us to state in the complaint the specific accumulated ill-gotten wealth, the assets of high values, as well as the bank accounts, then that would be also an evidentiary fact. And we have also to consider that insofar as this impeachment case is concerned, there are 3 pleadings which are already on the record of this impeachment court. The number one is the complaint. I have expressly read the pertinent provisions. And the second pleading happens to be the answer of the respondent. And what is stated in the answer of the respondent? Paragraph 10, in paragraphs 2, 2.3, and 2.4 in their answer, they stated, complainant suspect and accuse Corona of betrayal of public trust because he allegedly communicated ill-gotten wealth, acquired high-value assets, and kept bank deposits with huge deposits not declared in Salen. Paragraph 11.
Wait a minute. Did they admit, was there an admission in the answer with respect to this allegation, the supposed allegation?
I will state, Your Honor, please. In the last sentence of paragraph 11 of their answer, and I quote, at any rate, the allegations are flatly denied. The truth of the matter is that C.J. Corona acquired his assets from legitimate sources of income, mostly from his professional toils. And let me state also what has been stated in our reply. In our reply, page 25, paragraph 53.1, the complainants reserve the right to present evidence during trial on other expensive properties acquired by Corona and his family. And therefore, insofar as the law on pleadings is concerned, ill-gotten wealth is already an issue which has been joined, as stated in the paragraphs which I have quoted in the complaint, as well as the answer and as well as the reply. And therefore, we think that the contention that there has been no allegation of ultimate facts is entirely erroneous, inasmuch as the ultimate facts have already mentioned, and also it has been flatly denied in the answer.
Anyway, are you true?
Just for...
Are you true?
Yes, Your Honor.
Senator Pimentel?
Thank you, Mr. President.
Senator Pimentel.
Thank you, sir. I'm very much interested in the legal point raised by the lead defense counsel as to what amounts to a sufficient allegation in a complaint. And if I remember correctly, the Attorney Cuevas, the lead defense counsel, offered to submit a memorandum on this particular point of law. And I think, Mr. President, we should welcome the offer for the submission of a memorandum on this particular point of law, because at any rate, this will not affect the hearing schedule. And when we take up this question, when you, I will anticipate that when you object to the formal offer of evidence, then we have your memorandum to guide us in before we resolve this particular issue.
We will do that, Your Honor. And
So that's my point, Your Honor, that we should welcome the offer of the defense, and then if we do that, then of course also the prosecution, for them to submit their memorandum on this particular point, legal point raised by the defense.
Thank you, Your Honor.
Will you kindly allow the chair to say something? My understanding of the rules is that when a testimony is offered, the objectionable feature must be seasonably addressed by the opposing counsel in order that it can be recorded, the objection can be recorded. So that given this rule, the chair will allow the witness to answer questions with respect to the properties mentioned, subject to the continuing objection of the counsel for the defense with respect to the application of all of these questions to improving the issue of ill-gotten wealth, acquisition of assets of high value, and accumulation, keeping bank accounts with huge deposits, as well as some properties of the respondent not included in the SAL-N, because the proof of non-inclusion will be the document, the SAL. So, with that, that is the ruling of the chair.
All right. May I just make a 1-minute rebuttal, Your Honor?
Yes, please.
On the manifestation of my colleague in the prosecution. Dealing with the sufficiency of the allegation of the complaint. He made mention about the answer. He made mention about the reply. There is no such jurisprudence to that effect, Your Honor. You determine the sufficiency of the cause of action embodied in a complaint, not through the answer, not through the reply, but on the very allegation stated in the answer. That is elementary. I had been discussing that in my remedial law class. Maybe some of my students were absent when I discussed it. I made that clear. That was also my lecture before the...
Maybe some of your students were absent when you were lecturing on this point of law.
I hope not, Your Honor.
May I just make a rejoinder, Your Honor?
Now,
very short rejoinder.
Please go ahead.
As far as I can remember, when I was still in my law class, in the event that there is insufficiency, alleged insufficiency in the allegation of ultimate facts, the proper legal remedy would not be a motion to dismiss, but a motion for a bill of particulars. That would be all, Your Honor.
thank you, Your Honor.
What is the pleasure of the gentleman from Taguig?
Sir Presiding Officer, Mr. Senate President, may I ask some questions to both counsels?
The chair has made a ruling already.
Yes, Your Honor. This is clarificatory questions on the article to the two counsels.
Are you asking the two sides to answer questions?
No, Your Honor. I will ask the prosecution first some questions.
Proceed.
Thank you, Your Honor. Just to enable us to understand fully Article 2, listening to the arguments of the defense. First of all, you said that in Article 2, you said there is culpable violation of the Constitution and or betrayal of public trust when he failed to disclose to the public his statement of assets and liabilities. Yesterday, all of these SAL-Ns were presented. So is the prosecution now admitting that in fact it has been presented? And the second or the follow-up question, the more important question, in your eyes or in the judgment of the prosecution, is this the disclosure that the law requires?
No, it's not.
So first question, Your Honor, is that
it's not.
In fact, counsel, that
yes,
you are admitting that he has in fact filed it.
Just a minute. I'm not trying to teach anybody how to. The counsel for the prosecution is rendering an opinion. An acceptable proof in this proceeding must be under oath. If you want to convert the prosecutor to testify on this particular point, then let him take the witness stand to be examined.
With all due respect, Mr. Presiding Officer, the rules allows us to ask questions to both the defense and the prosecutor, to both the witness and also to the counsels.
Yes,
Sir, may I be allowed to finish? The issue is whether or not Article 2, in fact, if proven, will be a ground to impeach the President. So I'm actually only laying the groundwork for to impeach the Chief Justice. Actually, sir, I'm going to the question on 2.3 after he answers the first few questions. I'd just like to clarify what they are accusing the CJ of. So this will help me in my final judgment later on of whether or not the Chief Justice could be held guilty of the charge in Article 2 or whether Article 2 is a non-charge at all or is not grounds at all to impeach him as brought up by the defense counsel. So actually, sir, my questions is not about evidence and about the witness, but I'm trying to figure out what the prosecutors are charging the Chief Justice of. I just have to be fair. I asked the defense hard questions. If they are asking for a subpoena, I believe in their cause. But now that I have some doubts on their allegations, Mr. Presiding Officer, I just like them to clarify some matters.
Precisely, the ultimate fact to be considered here is the issue of disclosure. And the question asked was whether the counsel for the prosecution considers this submission of the SAL as the disclosure provided by law. He is being asked to interpret the law without taking an oath as a witness. And that's why I'm calling the attention of the gentleman that that is improper.
With all due respect, I do not think it's improper because that is precisely their charge, that the SAL-N was not disclosed. And if I was allowed to ask the question, my second question was, because they were surprised yesterday and they admitted it's the first time they saw the SAL-N, now that they saw it and now that it has been filed, are they still charging that it has not been disclosed because it should be disclosed in a certain manner? Or are they now saying that now that they see it, they're going to focus on 2.3 and 2.4? And I was going to ask, Your Honor, in 2.3, how can they know that there are properties not included in the SAL-N if, in fact, they haven't seen the SAL-N yet? That would have been the flow of my questions, Your Honor, if I would be allowed to just ask him those questions. If this does not have any evidentiary value, so be it. But it will allow me to understand their charge.
All right. Anyway, the manner of disclosing is provided by law.
Well, actually, the Senate President answered the question. No? The manner of disclosing...
Can
Yes,
I
please.
amplify my answer?
Yes.
To the question of the Honorable Senator Cayetano, he asked me whether or not the disclosure made yesterday, we are already abandoning our allegation in 2.2, which provides that respondent failed to disclose to the public his statement of assets, liabilities, and net worth as required by the Constitution.
No, actually, what the question to you, and the record will bear me out, is the presentation of the SAL. In accordance with the subpoena, is the disclosure contemplated under the law.
No,
the disclosure is defined by law.
Yes, Your Honor.
Not your opinion.
Yes, but let me state our position. It was only yesterday that the disclosure was made. As a matter of fact, the disclosure was made upon questions coming from the senators. The disclosure was made for SAL-N starting 2002 up to 2010. And it is our position that the disclosure of the SAL-N from 2002 to 2010 only on account of an impeachment complaint is not in accordance with the disclosure provided by the law.
Okay. Well, anyway, we will come to that at the proper time. So let us proceed with the trial.
Your Honor, may I finish my questions?
You have...
I have 2 minutes, Your Honor.
Yes.
Yes. The Constitution says that the disclosure is to be provided by law. So now it is settled that he did file his SAL, no, assuming that that's not being disputed. So the Republic Act that deals with the SAL-N says that you can examine it any time of the day, etc. So basically what you're saying is because that was not allowed by the Supreme Court, then you are charging him for not disclosing it. Do I understand it correctly?
Yes, Your Honor, and I want also to emphasize that the reason why the Supreme Court did not disclose it is that they have a deliberation, they have an agreement not to disclose it in the public.
Yes, Your Honor.
And the respondent Chief Justice actually participated and took part.
Not to cut you off, that's their defense, and we will get there when their time is there. No, it's just a preparation to my real question, which is in the third paragraph, which is part of the discussion now, 2.3 and 2.4. Sabi niyo po dito, it is also reported that some of the properties of the respondent are not included in his declaration of assets and liabilities and net worth in violation of the Anti-Graft and Corrupt Practices Act. At yung po nirereklamo ng defense, hindi pwedeng reports. And then sa next paragraph, suspected and accused. Ang question ko po, paano nyo po alam na merong properties na hindi kasama sa SAL-N kung hindi nyo pa pala nakikita yung kanyang SAL-N?
Well, actually, we were able to see the SAL-N of the Chief Justice yesterday, considering that the SAL-N was.
But when you made the articles of impeachment po, hindi nyo pa nakikita?
Hindi pa namin nakikita.
So that's why you use the word reported?
Yes.
Because you couldn't get hold of it?
Yes.
No, I'm just trying to understand why you use these words. 2.4, suspected and accused. So do you know if in fact are you accusing the Chief Justice of accumulating ill-gotten wealth and acquiring assets of high value and huge deposits or not?
We are charging him.
Or you're just suspecting that he does have it?
We are charging him, and our suspicion is based on the prevailing circumstances that we were not able to see the SAL-N of the Chief Justice.
And through this trial, you will show us the evidence?
Yes, Your Honor.
So what you're saying, Your Honor, is that because the SAL-N was not available, you were constrained to use these words?
Yes, Your Honor.
But in your interpretation, this is sufficient to fulfill the requirements of having the ultimate facts?
Yes, Your Honor.
But the defense is disputing that?
Well, we expect that, Your Honor. Of course, the defense would not agree with our position.
Just one question to the defense counsel.
Yes, Your Honor.
Your Honor, in one Supreme Court decision, the Supreme Court held that the complaint is sufficient if it contains sufficient notice of cause of action, even if the allegation may be vague or indefinite, or in the form of conclusions, in which event the proper recourse would be to file a motion for bill of particulars. I'd just like to try to understand your argument. Are you saying, Your Honor, that their use of the word suggested means that there is no cause of action or sufficient notice? Even, is it not cured because they use the word accused?
We are acquainted, we knew very well about that jurisprudence, Your Honor. And that applies only in actual civil cases, but not in criminal prosecution, for instance. One cannot be accused of having committed a crime on the basis of mere suspicion and so on down the line. But you will probably ask, but this is an impeachment proceedings, Your Honor. My answer is, if we allow that kind of principle or rule to govern the impeachment proceedings, then it will be violative of the Constitution on the right of a person accused of procedural due process. He's entitled to notice, he's entitled to present evidence in his behalf.
What about the word "we accuse"? Does that cure it, or do you take it separately from suspicion, or you take it together?
That we accused, and then if it is based on suspicion, that is no accusation at all, Your Honor.
Thank you, Your Honor, and my time is up. Thank you.
Thank you, Your Honor, also.
Senator Scudero. Yeah.
Thank you, Mr. Senate President. On the point raised by Senator Cayetano, I would have had questions to the witness, but I don't think the cross-examination is over. Congressman Barsaga?
Yes,
Kayo
Your Honor.
po ba o bahagi ho ba kayo sa nag-draft ng complaint na ito?
Well, actually, I was not. But actually, I read the complaint before I signed it.
I know. That's not my point. Sino po ba nagsulat nito? Dahil nais ko malaman yung intention sa likod ng mga nakasulat sa complaint. Sino po ba yung nag-draft nito?
Our lead prosecutor would be in a more competent position to answer that question, Your Honor.
May I ask Congressman Tupas then, who drafted, wrote? And there's nothing wrong with it. I understand the 188 did not, as long as they read it and that has been settled. Sino po yung nagsulat nitong complaint na ito?
Well, kami ang nagsulat niya na, Your Honors.
Sino po si kami?
Mga congressmen, merong ilang grupong congressmen ang nag-research, mostly members ng Committee on Justice.
You were part of it?
Yes.
I ask this, Mr. President, and may I ask that in the memorandum to be written by the defense, and I presume the prosecution will also write its own memorandum on the subject matter.
Yeah, we reserve a right to file a reply to that memorandum.
Bilang hurado kasi nalilito ako sa Article 2, sa totoo lang. Ang nakalagay sa Article 2, the Chief Justice failed to disclose to the public his SALN. Yun lang ang nakalagay sa Article 2. Pero sa loob ng Article 2, sinulat ninyo na maliban sa hindi niya dineklara, nilagay din niyo ron na hindi niya sinama lahat ng properties niya, and there is a third allegation that he amassed ill-gotten wealth. These are three separate acts that he failed to disclose, that he did not include, and that he amassed ill-gotten wealth. Pagdating ho kasi ng botohan, boboto kami hindi sa hiwa-hiwalay na tanong na ito, kung hindi sa isang article lang, Article 2.
Yeah.
In your memorandum, can you kindly explain, guide us? Kailangan ba mapatunayan nyo yung tatlong to bago kami bumoto ng conviction dito sa artikulong ito? 2 out of 3 lang ba kailangan nyo patunayan? Because in the ordinary course of events, each article must accuse the respondent of a singular, separate act. But Article 2 actually accuses the Chief Justice of 3 separate acts. The 2 not even mentioned in the title. So can you guide us when we come to the point that we will be voting on how we will approach voting on this subject matter? In your memorandum, I will not seek an answer now from both councils. Pakibigay po sa amin inyong opinion kaugnito dahil 2 out of 3 ba, 3 out of 3, 1 out of 3, dahil nais naming maliwanagan tungkol dito. Thank you, Mr. President.
Gagawin po namin, Mr. Senate President. Mr. Senate President, just a very short manifestation from the lead prosecutor.
Proceed.
We observed, Mr. Senate President, that since yesterday, the distinguished lead counsel of the defense has not only been objecting to our questions, which, of course, that is part of the right of the respondent, but also lecturing and lecturing us. Like, for example, Mr. Senate President, with respect to this issue, we are not presenting yet, we're not offering the TCTs, the deed of absolute sale. We are just actually marking it. And the counsel for the defense is already objecting. And it has already been stated by the Senate President that this is not yet time, and we lost around 1.5 hours because of this, Mr. Senate President.
Why I have already made a ruling. But,
yes.
So that there will be no question that we are trying to railroad this proceeding, I allow arguments to be heard by the people and by the audience so that they will understand what's going on. So, go ahead.
Okay, with that respect, Mr. Senate President, we submit because we are just concerned that we might not be able to present all our evidence in a reasonable, in a fair, reasonable manner. If, for example, to deal with a drug like this, it becomes a question of technicality. And I also would like to appeal to the counsel, to the lead counsel from the defense, that appeal not in legal term, but appeal in a layman's term to avoid unnecessary remarks, lecturing, which is not really part of this process. But I would love to listen to the distinguished gentleman, but not inside this impeachment tribunal. Thank you.
Anyway, Senator Drilon, you have. Let us finish these arguments and proceed with the trial.
Can we raise questions of the witness, Your Honor? Is
Yes.
it appropriate?
Proceed.
And I hope counsel for the defense will not raise objections to my question. Thank you, Mr. President. Can the witness again state his name? I have forgotten your name.
Randy A. Rutacchio, sir.
Randy
A. Rutacchio.
Rotacchio. Okay.
Rutaqquio, sir.
Mr. Rotacio, you are the Register of Deeds of the City of Taguig.
Opo.
Operationally, mayroon po kayong control at supervision sa buong tanggapan ng Register of Deeds ng Taguig.
Yes, Your Honor.
Now, yung lahat po ng mga